Good evening. Welcome on behalf of the Baker McKenzie International Arbitration Group globally. It gives me huge pleasure to welcome you all to this year's annual UCL Baker McKenzie lecture on international law and litigation. First, thank you to Philippe, to UCL and to Lisa Penfold in particular for all the hard work in pulling this event together. And it's a real pleasure for me and for Baker McKenzie to continue this now long relationship. Now, this evening's event is a first in a number of ways. It's the first UCL Baker McKenzie lecture to be fully virtual, albeit I do accept that in current circumstances, that's no longer as unusual as it once was. But what it does mean is that we are able to have many more participants listening to the lecture than might be the case if it were physically held in London, as has previously been the case. The second first is it's the first time that Philippe has introduced the lecture without wearing one of his very colourful ties. So that's another first. And then finally, it's the first time that the lecture has been delivered by a Baker McKenzie alumna. And it gives me, and I know that this is shared by all my colleagues around the world, many of whom will be joining us today and or looking at the recording of this, great pleasure that Professor Gabrielle Kaufmann-Kohler, who spent 14 years of her career at Baker McKenzie, has agreed to deliver this year's lecture. I will leave Philippe to introduce Gabrielle properly, but on behalf of Baker McKenzie, thank you, Gabrielle, for agreeing. Now, tonight's lecture on the topic of international law has rarely felt so relevant. The UK's place in the world legal order is currently at a huge turning point. We have a government which has demonstrated its willingness, if not its intention, to break international law, albeit only in a limited and specific way, while at the same time it heads out across the world looking for states to enter into treaties with, all that against the backdrop of heated negotiations with the European Union. And I'm sure we look forward to hearing Gabrielle's views either during the lecture or in the Q&A afterwards on all these exciting points. Now, finally, it's almost impossible to imagine the UCL lecture without our compère hors pair, Philippe Sands. So I will hand over to you, Philippe, to introduce the lecture and to manage the question and answer session afterwards. So over to you, Philippe. Thank you, Gabrielle. Very much looking forward to the lecture.
Thank you, Ed, and my thanks to you and all your colleagues at Baker McKenzie for this incredible support you've given us over so many years. It's really a feature for us, and thanks also to my colleagues at UCL for the support and for making this possible, in particular, Lisa Penfold. It is a real personal pleasure, I have to say, to introduce Gabrielle Kaufmann-Kohler, whom I've had the happiness of knowing for many years. I think I first appeared before you, Gabrielle, more than 20 years ago. I think I went down in flames. But even then, I always knew you are scrupulously independent and fair. And we always had that sense when we appeared before you. And since then, I've had the great happiness of sitting with you and seen also from the other side that absolute commitment to the integrity of the process and to an absolutely open mind on the facts and the law. It's a real happiness for me that you are our lecturer this evening. You, as many will know, have taught at the University of Geneva. You've been professor, you're now Professor Emerita, but you continue to teach on international private law and international arbitration. You are currently the Honorary President of ICCA, the International Council for Commercial Arbitration. You were president for a number of years. As Ed mentioned, you've been at Baker McKenzie and after that at Schellenberg Wittmer, and then you set up your own firm in 2008, Lévy Kaufmann-Kohler. You have been involved in literally hundreds of international arbitrations, mostly as arbitrator, very often, almost always as president, and that says a great deal. I think one publication described you as the most influential arbitrator in the world. You are as fine an arbitrator as I've ever appeared before or had the happiness of sitting with. But you've done something else, which is to basically begin that important process of bringing in some gender balance on a world that was very, very male for a long time and is now beginning to change. So for many, many reasons, it's wonderful you're with us. And of course, your chosen topic could not be more timely at a most incredibly interesting time for international arbitration. The subject of your lecture is international arbitration from Alabama to Brexit. We've already had a number of questions. You'll speak, I think, for about 30 minutes. We'll then have a conversation, you and I, for a short number of minutes. And then anyone who's watching, please feel free to send in questions under the Q&A. I'll be monitoring them. We've had quite a few in already in advance, and I'll do what I can to get as many to you, Gabrielle. So without further ado, Professor Gabrielle Kaufmann-Kohler, the floor is yours.
Thank you so much. Thank you, Philippe. Thank you, Ed, for this very kind introduction and for the invitation. It is an honor and a pleasure for me to give this annual UCL Baker McKenzie lecture. It is true that I would have preferred for all of us to be in the same room at UCL tonight. It would have been more pleasant, but then that is the world we live in. And we're fortunate to have the technology available. I've chosen to reflect with you tonight on the evolution of international arbitration from Alabama to Brexit. The Alabama arbitration stands as a marker for the beginning of modern day international arbitration. It took place in, now let me see, yes, this works. It took place in 1871-72 in Geneva and involved a dispute between the UK and the US linked to the American Civil War. You see the proceedings on the left on the PowerPoint. This is the Alabama room in the City Hall of Geneva. The Brexit dispute settlement mechanism is used here as a signpost for what is coming. And in between these two milestones, arbitration has seen a steady rise, expansion, harmonization, and then followed by challenges, criticisms, and reform initiatives. And that is what I have in mind to discuss now. Arbitration has existed since times immemorial, but present-day international arbitration took wing in the late 19th century, early 20th century, in the wake of the movement towards peaceful settlement of interstate dispute. That is the time of the English Arbitration Act of 1889, or of the launch of the predecessor of the LCIA, the City of London Chamber of Arbitration. The first international instruments date from the 1920s, concluded under the auspices of the League of Nations. It was the Geneva Protocol and the Geneva Convention on arbitration. The first ICC rules also date from that period. It's actually not a surprise, and we have to keep this in mind, that the need for contemporary international arbitration arose at that time. That was a time of economic prosperity, of free movement of goods, and worldwide commerce. The momentum is then brought to a halt by the crisis that breaks out in 1929 and World War II. It gathers speed again after the war in the 50s, this time under the auspices of the United Nations, where states, as you well know, adopted the New York Convention that you know as well is the cornerstone of the edifice. And that improved on the League of Nations texts of the 20s. Post-war then also brings decolonization, to allow the newly independent states to attract foreign capital that is necessary for their development. The idea comes up to protect foreign investors by granting them access to through investment treaties, and to grant them direct access to international arbitration for claims against host states. This is also when the ICSID Convention sees the light of day. That is a treaty like the New York Convention that met with resounding success. At the same time, the states start entering into investment treaties, literally thousands of bilateral and multilateral treaties. The following decades then witnessed the opening of China, the fall of the Soviet Union, the rise of emerging markets, and as a result, numerous new actors enter the scene of international commerce, and transport means, communication, technology, the internet, increasingly facilitate exchanges, with the result that the planet becomes the global village that we know today. And carried by this globalization movement, international arbitration expands. It does expand in three dimensions: territorial, substantive, and quantitative. First of all, territorial. While international arbitration was primarily the domain of Europe and the US, it is progressively practiced in all regions of the world. Legal systems that were rather hostile, for instance, in Latin America, abandoned their reluctance. In parallel, the subject matters that can be submitted to arbitration also expand: IP, competition law, shareholders disputes, many others. And this seems to be a continuing trend nowadays, with banking, finance, art trade disputes being more and more the domain of arbitration. This is also the time, by the way, when international sports arbitration develops into a practice that sees now about 600, 700 cases each year before the Court of Arbitration for Sport. It is, of course, no surprise that this territorial and substantive expansion, the figures, the numbers rise too. The ICC had 5 cases in 1920, and they started 869 new ones in 2019. You could not make the same comparisons with most of the other arbitral institutions, simply because they did not exist at the early times of international arbitration. That expansion is coupled with a vast movement, a true wave, hence the wave on the slide, of harmonization of the law and practice of international arbitration. During the period of growth, the states leave broad freedom to the private actors. This is an era of deregulation here, but equally in many other sectors. And it is true, you might object that in the 80s and 90s, there was a flurry of new international arbitration legislation. The Arbitration Act of 1996 is, of course, a good example. But these new acts merely provide a very general framework. They reinforce party autonomy, they strengthen the powers of the arbitrator, but they provide little state control. And the private actors somehow paradoxically seize the freedom that the state offers them and rush to quote unquote codify good practices of arbitration in a profusion of soft law. Some soft law texts have become so indispensable in day-to-day practice that one could say they have actually hardened. This may also be the place to mention the formation and the role of the global arbitration community. That community, as epistemic, stands for a community of knowledge, has its association, its publications, its gathering, its lectures, and this is a very good example of it. And even online, as we do tonight, the community exchanges views, engages in dialogue, shapes the practice, contributing decisively to the wave of harmonization by a phenomenon that could be called cross-fertilization or cross-pollination. So here we are at the end of the 20th century, early 21st century. Driven by globalization and the growth of international commerce, arbitration has kept expanding and harmonizing. The construction looks robust, sturdy, firmly anchored on its multiple foundations, treaties, national legislation, arbitration rules, soft law. Yet the first cracks in the building appear already mid-late 1990s. At first, just a few isolated voices, some academics and some NGOs. And the criticism is initially expressed in respect of NAFTA Chapter 11 arbitration, but soon it embraces investment arbitration in its entirety. It is understandable that it was expressed about investment arbitration because investment arbitration brings states to justice. It involves matter of public interest, issues such as natural resources, environment, public health. It also burdens fiscal resources. We hear some criticisms about commercial arbitration as well, but that is to a much lesser extent, and more significantly, it does not question the fundamental values underlying commercial arbitration. And because the main challenges lie, as I see them today, with investment arbitration, I will now focus on this category of dispute settlement, but not without signaling when criticism or a reform also captures commercial arbitration. So this leads us then to my second part about the criticism and reforms. But before looking at the criticism, it may be worthwhile pausing and looking at the context and trying to understand it. The backlash against investment arbitration has come as a surprise to many in the arbitration, international arbitration community. But if you think about it, it actually is just a reflection of a changing world. Investment arbitration was created in part as a response to decolonization. It allowed businesses from former colonial empires to invest in newly independent states, benefiting from certain guarantees. And it offered these states access to foreign capital to finance their development. Over the last decades, the balance of power has shifted. These states and other emerging economies have gained increasing economic and political weight on the world scene. And as part of this new balance, the protection of investment is often seen as curbing the sustainability of development at a time when sustainability is regarded as vital in light of the global challenges that the world faces, such as pandemic risk or climate risk. And still speaking of the balance of power, at the same time as the emerging countries are becoming powerful actors in international relations, the public opinion in political circles in developed countries were shocked to discover that investment arbitration was not a one-way street. It could turn against their own state. And finally, the amplification of the critique can also be explained by the return of the state following the financial crisis of 2008, which return is often associated with protectionism, with nationalism or populism. And obviously with the COVID measures, we now experience a new manifestation of this return of the state. So having looked at the context, what are the criticisms that are raised against investment arbitration? They're often called concerns. You know them, so I will be brief. The first one is excessive cost and duration. That is a recurrent theme in commercial arbitration. We have heard this for many years by now, and the arbitral institutions have taken an energetic action to remedy this defect, and I have no real doubt that they will yield results, and these results could be applied to investment arbitration as well. Maybe the increased digitalization that we experience now, virtual hearings could also increase efficiency. The second criticism is about the lack of transparency. That should actually be a past concern in investment arbitration. Awards are practically all published. UNCITRAL has created the legal framework to conduct arbitrations in a transparent manner by the transparency rules and the Mauritius Convention, and most recent treaties do incorporate these texts. So it's more a question of political will to implement the existing framework than a lack of rules on transparency. Commercial arbitration, by the way, is not spared, was pressures towards more transparency of the operations of arbitral institution, and also a demand for better access to awards. Arbitral institutions do respond, in part at least, to these demands. For instance, the ICC will publish all awards 2 years after their issuance, unless one of the parties opts out. So it's not an opt-in mechanism, it's an opt-out. The third main concern or criticism is the lack of consistency in legal outcomes. It says that recurrent legal issues, especially on treaty interpretations, are given inconsistent answers. Outcomes are like what you see on the slide right now, disorganized, chaotic, when we would like them to be like this. And that is an unavoidable consequence of the fragmented architecture of the dispute settlement system that is composed of one-time ad hoc tribunals. No permanent body, no Supreme Court to bring order among inconsistent results. To be fair, on some legal issues, there is a jurisprudence constante that has or is taking shape. The fourth and last criticism is probably the most important one, argues that investment arbitration lacks legitimacy. It focused mainly on the arbitrators, on their person, on their conflicts, on the method of appointment, which distinguishes them from permanent judges. In international law, legitimacy is derived from state consent. Here, that consent was clearly given because the states have entered into the treaties. But legitimacy can also be regarded in non-legal terms, and that is probably more appropriate here. Under the dominant theory of Max Weber, legitimacy designates the acceptance of the exercise of authority by those affected by the exercise. They voluntarily obey orders, not because they are coerced, but because they recognize the authority as justified, or if you prefer, as legitimate. And to understand the legitimacy criticism, one must keep in mind the context that I have sketched earlier, and also recall that there are more democratic states today than decades ago when the system was set up. You see here a comparison about over 40 years. The blue states are democratic, the brown states are autocracies, and the beige ones are in between. Now, one could argue about the classification of one or the other state. That is not my purpose. My purpose is to say that the increase is striking in 40 years. Now, why am I saying this? Why does it matter? It does matter because democracies trust institutions and they distrust powerful individuals who are not elected or not otherwise embedded in a democratic governance process. And arbitrators are not elected nor appointed in a framework of a democratic selection process. And arbitrators are powerful because they rule on the international responsibility of states. These two images, I think, provide a good illustration of the contrast between institutional justice and ad hoc tribunals. On one side, you have the Peace Palace, well known, where the ICJ sits, an institution whose authority here is symbolized by an imposing building. On the other, you have an ad hoc tribunal on a sidewalk without a building, without an institution, and without the authority that comes with it. The lack of legitimacy might also be linked to a lack of diversity of the decision makers. I think Philippe Sands has mentioned diversity a while ago, addressing gender diversity. If I now take another type of diversity, which is regional diversity, you have empirical data shows that Western arbitrators are by far prevalent in investor-state dispute settlement, when we know that many non-Western states are respondents. And you have to look at the far right at the bottom, where you see that all non-Western regions arbitrators are 26% and the Western regions are 74%. So having now framed the criticism, let us look at the cure. And here again, I will focus on investment arbitration, but may flag when a cure also applies to commercial arbitration. Abolishment of ISDS, investor-state dispute settlement, will of course be a radical cure. It is sometimes envisaged, it is sometimes implemented. ACMEA comes to mind, certain revocation of treaties, new treaties that do away with investor-state dispute settlement come to mind. Another proposal that's often sometimes made is simply to maintain the status quo. That seems that is not a viable option for the simple reason that the reform process has started. UNCITRAL Working Group 3 is well engaged in a vast reform project, and states do amend their treaties or enter into new treaties, making changes of procedure and substance. On substance, we see a rebalancing act towards more space for regulatory power and public interest. And a procedure, while it is true that some states do away with investor-state dispute settlement, most of them do maintain it, but seek to better streamline or control the dispute settlement process. So that leads me now to the reform. There are several reform options. The objective, I would submit, is to solve the main criticisms that we have just sketched, while at the same time preserve as much as possible the positive achievements of the current system. And if I could name just three, I would say depoliticization of the resolution, flexibility of the system, and quality of the process and of the decisions. There are several options. As you see here, one is light like feathers, one is heavy like weights, and one is intermediate. The light reforms is sometimes called incremental because it would add, in the sense of improve on the existing system. The change of the appointment method would be of the arbitrators would be one. They could be chosen by an institution or from a pre-screened roster. Also on the agenda is the adoption of a code of conduct for arbitrators with rules on disclosure, double hatting, repeat appointments, the incorporation of rules on third-party funding, the security for costs, to name just a few. The current ICSID rule amendment go in this direction, as do a large number of the proposals pending in the Working Group 3 of UNCITRAL. An additional light reform is the increasing addition of mandatory mediation or other ADR forms as a precondition to arbitration. Recent treaties often provide for it, and mediation has a lot of support in Working Group 3. With the signature of the Singapore Mediation Convention, mediation has actually gained respectability. Like arbitration, it now has its convention, and it can be said to be on equal footing. And no doubt that the increasing influence of Asia was a less adversarial dispute settlement culture does play a role in the boost that mediation receives. The intermediate option falls within what sometimes is called structural or systemic reforms, would imply creating a permanent appellate mechanism and grafting that then onto the existing system, was the expectation that the first instance that would remain unchanged would somehow be legitimized by the existence of an appeal. That would certainly well resolve the consistency concerns. At the same time, it is a very difficult legal construct because of the necessary interaction between the existing arbitration system and the appellate mechanism. It will also make proceedings longer and costlier when this is precisely one of the main critiques. The heavy option is more drastic, also structural. It would contemplate the creation of a permanent multilateral investment court. This option would best resolve many of the concerns. At the same, however, it is also a path that is fraught with pitfalls and thorny questions. Who will appoint the judges? How will they be selected? How to ensure that they're competent, impartial, protected from pressures, that diversity is achieved, who will pay for this course? All of these are questions that the reform initiatives will have to resolve. Which one of these options does the Brexit withdrawal agreement dispute settlement mechanism resemble most? First of all, we should not overlook that the Brexit arbitration system is state-to-state dispute settlement, not the asymmetric investor-state dispute settlement mechanism. But subject to this, it seems to me to straddle the light and the heavy option. It provides for the UK and the EU to each appoint 10 individuals and to jointly appoint 5 more as chair. These 25 people will then constitute a list, or if you prefer, a pre-screened roster, from which the 2 disputing parties will then choose 2 members of the list each, which will then be the party appointees, and the party appointees will then choose a chair from the 5 chairpersons to form a 5-member panel. The PCA will step in if there is appointing authority if needed, and will also administer the arbitration. Is the Brexit arbitration mechanism a pointer for the future? Well, time will tell. What appears likely is that the reform will offer a menu of options from which states will make their policy choices. Well, it will certainly be incumbent, well, it is incumbent on states to make the policy choices. It seems equally clear to me that the international arbitration community, practitioners, and academics alike should contribute to the process, informing the nature and consequences of the policy choices. In short, there is a lot on our plates for these coming years. But if we cope with the content of the plate, the road should lead to the light. I thought that at the beginning of a pandemic, what could be a long pandemic winter, I should not leave you with the picture of the full plate, but should find something somewhat more encouraging. And so this is what I have, what I'm coming up. In more prosaic terms, I would hope that the reforms could lead to an international justice system in line with the needs and values of the 21st century. And I thank you for your attention.
Thank you, Gabrielle. Thank you so much, Gabrielle. You've raised so many issues to address. I want to jump in, if I may, and take your historic context. Alabama, the arbitration occurred at a time where there were no standing international courts and tribunals. And much of the 20th century was dedicated to the elaboration of the bodies that we're now familiar with. The Permanent Court of International Justice being one of the first, a Latin American Court of Justice was the very first, and then all the way through, right up to the 1990s with the International Criminal Court, the WTO appellate body, and the Tribunal for the Law of the Sea, building on the achievements. And then we reached the first part of the 21st century, and something happened. Something happens in the United States and the United Kingdom. The United States basically turns against the multilateral bodies. We now live in a moment where the US single-handedly has basically sought to kill off the WTO appellate body. We find the United States slapping sanctions on the prosecutor of the International Criminal Court. I mean, it's an attack on the very institutions the US has done so much to create in the middle part of the 20th century onwards. And then with Brexit, we see that a large part of the rationale for Brexit was to get out of the jurisdiction of the European Court of Justice. But of course, we need dispute settlement. And so what is put in its place is arbitration. So I just wonder whether, stepping back now, have we crossed the high watermark for standing international courts? Is the move to arbitration, the demise of the WTO appellate body, the attack on the European Court of Justice, what is really motivating it? And is it sustainable over time, or is this an interlude before we return to the kinds of standing bodies that in some contexts you've argued for, a sort of multilateral court for investor-state dispute settlement? Bigger picture, what is happening here? What's really going on?
It's a difficult question, and only time will tell. It's of course a time of crisis, of multilateralism, and it may seem paradoxical to speak now of the creation of a court. The EU has advocated this very strongly, has implemented it in some free trade agreements. Some other states are very much in favor of it, others are heavily against it, not only the United States, but some others as well. And others are difficult to read because it's not very clear whether they are for or against it, or just waiting to see what happens. We will see how the reform evolves. And that is why I do think that we will have a menu of options where the states will pick and choose. Will there be a multilateral court as part of one of the options? Maybe, but it's still open. Of course, we have a lot of experience by now with international courts. We have also very detailed scientific studies of how they work, how our judges are appointed, what works, what doesn't work. And if one draws lessons from this, accidents, if I call it like this, was the blocking of the WTO appellate body could be avoided if we had a fallback appointing authority that body could continue to operate. So there are ways of setting up a court. At the same time, the question which is open is whether there is the political will, if that is a good time, if we have to wait further and just implement some lighter reforms. The appellate body seems to have more, seems to be more popular, maybe just because it is in between, difficult to say.
I mean, one way of looking at this is that on the sort of agendas of Messrs. Trump and Johnson is a sense that somehow states which perceive themselves to be powerful are less able to control the practice and the direction of standing courts. Whereas with arbitration, somehow the perception is that there is a greater degree of leverage, more power, a move to bilateralism and away from multilateralism. What does that tell us about, if it's right, about perceptions of legitimacy, that certain interests are better able to control outcomes in an arbitral model than in a judicial model?
Is that so? Is that really so? I wonder.
Well, there's never, for example, there's never been a finding by an arbitral tribunal in investor state against the United States. The United States has never lost a case. And the countries that tend to be clobbered, I mean, let's call a spade, are, should we say, the less powerful. And is there a problem here? Does that indicate that there's an issue in arbitration? Or is the United Kingdom, which of course is now really a middling power, going to get a rude awakening. It's going hurtling towards arbitration in the expectation that it's going to be able to control the outcomes, but in fact, it's going to be on the receiving end, like Spain is on the receiving end, like Italy is on the receiving end. What's the sense of the direction of travel?
What? Let me return the question. What would you say?
I'm not the lecturer, but
no, but you were asking this. It's difficult to tell, frankly.
I mean, let me put it another way. Do arbitrators have the authority to come down strongly on powerful states in the manner that standing international courts have the authority to come down on powerful states?
Why would they not? If they apply the treaty and if the situation is such that the decision must go against the powerful state, then they should make this decision. Now, do they not dare doing it? I wonder. Would a court do it more easily? I'm not that certain.
Well, courts have begun to do it in the context of the International Court of Justice. There are rulings now against the bigger interests. But we also see, for example, in the field of the law of the sea, an Annex 7 arbitration tribunal had no hesitation in finding against the People's Republic of China on the South China Seas case. It may be that there is a distinction between investor-state arbitration and interstate arbitration. I don't know. I'm throwing ideas around. I'm trying to understand the bigger sense of what's going on here. There was a rush towards standing courts in the 20th century, the second half, and now there seems to be, at least in the eyes of the United Kingdom, the United States, a move against that direction. And I'm trying to understand why that is.
I have never really explored the analogy was into state-to-state arbitration, but it seems a fruitful one. Why would arbitrators in a state-to-state arbitration make rulings against the PRC, for instance, and not in an investor-state arbitration? It's difficult to understand. Is their status different? I would not say so. They're both, in both cases, they act under a treaty. I have some difficulty seeing why that would be different.
Yeah. Okay.
Is it linked to the people? Is it, or maybe the ad hoc tribunal that walks on a sidewalk, like in my picture, doesn't feel it has the authority to make decisions because it doesn't have this somehow this institutional backing. That could be the case. Yes, there's a much broader, much bigger, larger vulnerability of ad hoc tribunals.
Well, I mean, we know, again, without mentioning any names, that some of our colleagues who sit on arbitrators are rather more concerned about repeat appointments. Standing judges don't have that concern. They know they have a degree of tenure, they have a degree of security. I mean, obviously, one's not going to mention any names or anything, but we know that perceptions of independence from within vary as amongst the players. And, you know, the perception has been created in the field of investor-state arbitration in particular, that it is lucrative for arbitrators, it's lucrative for the law firms. Does it deliver justice for the taxpayer? That is one of the legitimacy concerns. And when you hand over something like Brexit, which raises so many potential issues, is it right, some people will ask, to be bringing in the private practitioners and the law firms to deliver justice rather than permanently appointed judges on matters of such potential significance? Again, I raise it as a question, I'm not expressing a view.
That is what you mentioned, a few aspects that made me think that the court would be a more impartial place, because there's no conflict. There may be conflict of interest, but not at all in the same way like in investor-state arbitration. No concerns about security of tenure, no concerns about financial security. There can be other issues of pressures exercised over the court by the constituting states. So that needs to be dealt with. How do you ensure expertise on the court? That needs to be ensured too. But that all can be done by screening bodies or other mechanisms.
Let's go to some of the questions that have come in from our audience. We've got a lot of questions, and I apologize to everyone. We're not going to have time to deal with all of them. From my old colleague, Cherie Blair, now at Omnia Strategy. Are virtual hearings the way ahead for international arbitration? You ended with COVID. COVID has changed our lives, Gabrielle, in a very real sense, in many ways not a positive sense, but virtual hearings, not so bad, eh?
No, virtual hearings. Thank you for the question, Mrs. Blair. Virtual hearings work very well. I must say that I have had a good number now, and at least as an arbitrator, I have the impression that I hear the parties as if I would be in the same room. It may not be as nice, but it's very functional, and it works well. It may be more difficult for counsel in terms of coordination of teams and the like, but that those who are used to it by now also have good practice with it. Some still argue that a virtual hearing is not a hearing, and do you have a right to a physical hearing? To me, a virtual hearing is a hearing. What is a hearing is a synchronous exchange of argument and gathering of evidence with all relevant actors present, and that is certainly what happens in virtual hearings. So I could think that virtual hearings also reduce costs significantly, and I could see that even once the pandemic is over. Well, there may be other pandemics and unfortunately, but even when it is over, we will continue to use virtual hearings. Maybe not in every situation. The question is then, when is it worthwhile having a physical hearing? But I would see many hearings continuing to be online.
Another question from Owen Bocott. Does arbitration have the authority to contribute in a legitimate and effective way to the resolution of the kinds of questions that might arise in relation to Brexit and its possible future arrangement with the European Union?
Well, it depends what you name authority, right? The simple answer to this is the authority is given to arbitration by the withdrawal agreement, and therefore there is a foundation for jurisdiction, and the authority is recognized by the European Union and by Great Britain. Now, is this authority in the more moral sense or ethical sense? That is a more difficult question, and that is the one I try to address with legitimacy, right? Will there be an acceptance of these rulings, even though they are given by 5 individuals who are not standing members of a judiciary? That continues to be a good question, I would say. 5 is better than 3, by the way. We have seen that some psychology and sociology studies on group dynamics show that 5 is a very good number for decision making. Better than 3 because with 3 the individuals are somehow too exposed, and better than higher numbers because then people are less engaged. So 5 is almost the ideal number. It's not a surprise. Many interstate arbitrations also have 5 members, and many Supreme Courts, if you look at chambers or in Supreme Courts, national Supreme Courts, you would see that 5 is also a very frequent number.
You, another question that has arisen in relation to the question of legitimacy. To what extent do you think that procedural challenges to legitimacy in investor-state arbitration, for example, the identity of arbitrators, the appointments by investors, problems of public participation, to what extent are procedural challenges to legitimacy different from substantive criticisms? Failure, for example, to apply laws in the field of the environment or human rights, or due regard to legitimate public interest? In other words, what's the relationship between substantive and procedural critiques to the system of arbitration?
Probably the procedural critique may well be a reflection of an insatisfaction about the actual substantive application of the law. That would need to, we have seen this, but not exclusively though. If you think, for instance, about the arbitration that have attracted a lot of media attention, like the Philip Morris cases, both Uruguay and Australia have been lost by Philip Morris. And at the same time, there was an outrage that among public opinion and in civil society that Philip Morris could bring these cases at all. So, so there may be just the existence of the remedies and who gives the decisions may in and of itself, in terms of procedure, be a reason for legitimacy concerns.
Yeah. Another question on legitimacy. A lot of the questions are focused on legitimacy. To what extent do you think that legitimacy-based critiques of international arbitration are attributable to the aspiration or the function of self-regulation? In other words, the community regulates itself rather than has external forces regulating its activity on issues of conflicts or on other matters.
It is the question about the arbitration mechanisms having their own regulation of.
Yes. Should there be more external regulation?
Yeah. That's certainly part of the criticism, yes, in the sense that, for instance, disqualification in ICSID has been very much criticized because it is the other 2 arbitrators who render the disqualification decision, which is not a good system at all. It's a system that the states have set up, actually. So there is this, but that all leads towards having rather a court than an arbitral system, because the arbitral system will generally have its own self-regulation. Even if it is not ICSID, investor-state arbitration, it can be under UNCITRAL or other rules. It will be under national arbitration law, and so will be under the supervision of the local courts. but you will generally have an arbitral institution that will somehow self-regulate, and what the courts will say will be limited to the annulment of the award, which is an important role, of course.
Yeah. I've got a number of questions on various EU matters, and I'm conscious, of course, that you can't trespass because of cases you may be sitting on or may sit on in the future. You need to be a little bit careful. But one, of course, that does attract a lot of attention is you mentioned the Achmea case and the Court of Justice of the European Union's practice and judgments in relation to the capacity of individual member states to enter into bilateral investment treaties going forward. And the question that comes is, do you consider the approach of the Court of Justice of the European Union, and in particular its approach to the autonomy of European Union law and the relationship between bilateral investment treaties and EU member states, do you think that the approach of the Luxembourg Court is justified, or has it been too dismissive of the arbitration system established by other international agreements? Putting it another way, is there a turf war underway here in which the European Court of Justice is somehow protecting its prerogatives as compared to other institutional mechanisms for resolving disputes?
As you said, I have to be careful here. So it seems to me, rather than speaking of a turf war, it seems to me that the European Court of Justice is precisely the European Court of Justice. It has its angle of approach. It has its own perspective, which is the promotion of European law. And so that gives it a certain angle of view that is very different from what investment tribunals would have, which come from general international law. If I can pass the rest of the question.
I've understood, Gabrielle. There's one final question, because we've already gone slightly beyond time. We just had 1 hour. That's the limit, I think, that people can sustain decent attention. And it's a final question, and I'm going to personalize it slightly. The question is, do you think that standing courts will be sufficiently attractive for judges and arbitrators so that the quality of justice delivered is not inferior to the quality delivered by ad hoc tribunals or arbitrators? Putting it another way, to personalize it, could you imagine sitting on a standing court rather than the life you currently have as an ad hoc arbitrator?
Yes, it would be a very interesting experiment. Yes.
Because?
Because I've never been on a court, and I'm always interested in new experiences, and it would be, I'm sure, the dynamics of a court are different from the dynamics of an ad hoc tribunal, and it would be very interesting to see how that works, and not obviously the resolution of the disputes would in and of itself also be interesting, but that exists in both systems.
Yeah, well, it may happen one day, Gabrielle, who knows?
Who knows?
You will have the experience. I'm afraid we've run out of time. I want to thank you on behalf of everyone who's attending, and it's a very large number in these very difficult circumstances for everybody. You have been so generous in your time. You've answered all of the questions. Many more have poured in. On behalf of UCL and Baker McKenzie and everyone who's had the privilege of being in on this call, thank you so much for spending an hour with us. Your lecture, I think, will be written up and made available, and this recording will be made more widely available. I end by thanking you, Gabrielle, for being with us today. Thank you so much.
Thank you so much to all. It's awkward not to see everyone, but let me thank everyone for the attention. Goodbye, everyone.
Be well, everyone, and be safe.